Welcome to Sakshi TV special NRI talk show, immigration talk show. So without any further delay, let us welcome Mr. Somireddy Garu onto our show. But before we get onto the show, please note that Sakshi TV now has 5 immigration shows every week. On Mondays with Somireddy Garu, on Tuesdays with Kaveti Garu, on Wednesdays with Prashanti Reddy in English, on Thursdays with Chand Parvatnini, and on Fridays with Manu Nindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 866-725-7441. If you need any specific legal advice, please contact the attorney directly. Mr. Somireddy needs no introduction, but if you need consultation, definitely log on to their firm. They have a wealth of free information and online tools in the hands of immigrant community. So without any further delay, let us welcome Somireddy Garu on our show. Hello, Somireddy Garu. I hope you're doing well. It's lovely to have you back on our show again.
Thank you, Andy.
Yes. So Somireddy Garu. Sorry?
Yeah, I just wanted to say hello, everyone.
Yeah. So Somireddy Garu, actually, we are kind of having a show after quite some time. So I thought, why don't you introduce yourself a little and a little bit about your law firm to the viewers watching the show, in case there are new viewers, they'll know a little bit more about you. So go ahead and.
Yeah. Hello, everyone. My name is Santosh Reddy. I'm the founder of Somireddy Law Group. We are a full-service law firm with offices in Virginia, New Jersey, North Carolina, and India. Our core areas of practice include immigration, litigation, corporate, and employment law. So we handle all sort of immigration matters, including H1s, L1, green cards. We handle dual USCIS audits. We also handle any employment litigation matters, like any whether breach of contract, non-succession, non-compete clauses, some family law matters, as well as criminal law matters.
Yes.
So we're currently licensed in 14 states and the federal courts. So we'll be, for more information, please visit our website.
Sure. Thank you so much, Santosh Garu. So, Reddy Garu, today we thought we'll discuss a little about the layoffs of 2024 fiscal year. I'm so sorry. So basically, there has been quite some, a lot of information that we, Sakshi TV USA, has got, and a lot of people, especially NRIs, Telugu NRIs, have been complaining that there have been a significant job layoffs, especially this year. So you as an immigrant lawyer, what do you think? What is the current situation right now?
Yeah. So right now, I know the market is not as good, but definitely things would improve in the next few months because since it's election year, I'm really hoping that we should be able to see the market has already started improving a little bit in the last couple of weeks. So I'm hoping that things should get better by September or October. But until then, yes, the immigrant community especially would have a lot of issues in navigating through their immigration process because of the huge number of job layoffs.
Yes. So do you think, Somireddy Garu, this is because of the US elections that are taking place, or else is it because of the market downfall?
Not really. It's a market condition. Of course, every time there will be like ups and downs, right? So now we had a very great, years last year and the year before. So this year, I think it's a little dull, but definitely things are going to get better.
Yes.
Yeah.
So Somireddy Garu, when let's say I am a H1B employee and I've been an H1B employee since the past 2 years. So let's say my job got laid off, and what are some first initial steps that I should be doing? Should I go notify my immigration attorney, or should I get anything special? So let's start with the basics. So I got laid off. What am I supposed to do?
Good. So once a person gets laid off, right, they have 60 days to either apply for a change of status or to move to a different employer or leave the country. Okay. So here the first thing that they need to look at is whether they have a valid visa stamping in their passport, right? So assume that you have a valid visa on your passport. So even then, if that is the case, then I would typically recommend that they can just apply for a change of status to B1, B2, and while the B1, B2 is pending with USCIS, if they're able to secure a new job, right, then they'll be able to file for a change of status to H1B again. Sometimes USCIS might deny their extension, change of status application. They didn't approve the H1B, but without change of status, right? So if that happens, since those who have a valid visa in their passport, they can just travel outside the country and then come back using their existing visa. So for them, things will be very easy. And so for those people, I recommend that they apply for a change of status to B1, B2. Okay, because they can always get back to H1B easily. Not only that, once you apply for a change of status to B1, B2, if you get a new job, right, you cannot start working for the new employer with the receipt notice, because now you are authorized to stay in the country based on this pending change of status application to B2, right? So, or either it could be H4 also. Since you are not no longer on considered to be on H1B, you cannot start working with the receipt notice. You have to wait until the H1B is approved with I-94. So if you don't get the I-94, then you may have to travel outside the country. And if you already have an existing visa on your passport, you can use that existing visa and enter back into the country. The other challenge that you would face is that B1, B2 applications are taking more than 6 to 8 months. Okay. But you can request a B1, B2 only for 6-month period. So if you did not receive a response from approval from USCIS within the 60 days, within the 180-day period, which is 6 months, right? So you still have to leave the country. Whereas if you have applied for a change of status to F1 or H1B or H4, if you apply for a change of status to F1 or H4, right, then you don't have to leave the country within the 6-month period. Because for F1, they are authorized, once the petition is approved, they are authorized to stay here until the validity of their I-20. Right. So if you think that you may not be able to secure a job within 6-month period, then I highly recommend that you may if you wish to continue studying any course, then I recommend that you change your status to F1. Not only that, if you're applying for a change of status to F1, there is premium processing that is available to you, so you can get the decision within 15 days. Unlike B2, where you have to wait for months, 6 months, or maybe 8 months.
Yes. Yeah.
In certain situations, once the F1 is approved, then the candidate, depending on the course that they are doing, they could be eligible for what is called curriculum practical training, CPT. Right? But that CPT has to be an integral part of their course curriculum. Then only it is valid.
Got it.
The other option that is available is to apply for an employment authorization, right? So for people who have an approved I-140 and who have been living here for quite some time, and if they have if they have the children in high school, or if they cannot leave the country due to medical reasons or whatever, right? Or if they have a house mortgage that they have to continue paying and all, then they can apply for emergency like emergency EAD, okay, which will allow them to continue staying in the country and then also work. So it does not give them a status. So since it doesn't give them a status, they will have to go out of the country to apply for adjustment of status when their date becomes current. But at least until then, they can continue staying in the country and then be eligible to work.
Got it. So, Somireddy Garu, my next question to you is, so like you said, you gave me a certain number of options and I'm satisfied with it. So now let's go to the next step, which is the documentation. So what kind of important documents should I be having or should I be getting from my ex-employer? And also if let's say I am getting even hired by a new employer, what kind of documentations should I be carrying or must I have to ensure that there are no other issues coming in future?
The most important thing would be your H1B approval notice, which typically you would have, and then also your pay stubs, right? So the pay stubs typically show on the date until which you are employed with the company, right? And also, just because you have there's a lot of misconception regarding the 60-day period when the date the 60-day period starts. A lot of people think that, hey, since I'm receiving pay stub until so and so date because of some severance package, my 60-day period starts from the date my severance ends. That's not true, right? No matter how long, even if you get 6 months severance package, the USCIS will only look at your last date of employment. So, for example, today I get laid off, right? June 17th, I get laid off, right? And I'm receiving 6 months of severance package, right? Then maybe the severance package they pay the regular wage, right? So even though I'm getting paid regularly for the next 6 months, my 60-day period starts from today. Okay.
Got it.
Yeah. So if you're applying for a change of status to B1, B2, typically when we are initially filing the case, we don't even mention the reason why we are applying for this, right? You just apply it and then they have been approving the petitions, right? If you're trying to apply B1, B2 for the second time, for example, if you're trying to extend that B1, B2, that's when you're receiving RFAs asking for a lot of information regarding to prove that you have a residence abroad and that you intend to leave the country and all that stuff. Okay, and most of the times what happens is when you apply for B1, B2, right? So the B1, B2 application will be pending for like 6 months or so. By that time, you'll be able to get another job and then apply for a change of status to back to H1B.
Got it. Yes. Somireddy Garu, I just want to ask you a question, because this question was pretty common anytime we have this kind of discussions. So this was actually one of the most interesting questions that we got very recently, which said, if I'm not wrong, his name was Ramesh. He texted even me personally. So he asked, can I work as a freelancer if I am searching for a job, and if his job got laid off? And they were like, can I work something as a freelancer, or do I have any of those rights? So as a lawyer, can you simply explain this term and explain all the situation?
So he cannot work as a freelancer, right? So for any immigrant, right, for any immigrant to be able to work, they have to be authorized to work. Certain work authorizations allow you to work for any employer. Like, for example, regular EAD. EAD would allow you to work for any employer. But there are certain other work authorizations like H1B or L1, which will allow you to work only for that particular employer who has sponsored your visa, right? So unless he has an employment authorization, he cannot be working as a freelancer.
Got it.
Okay, see the other problem that we have been seeing lately is that a lot of people start their own companies. Okay, I know nobody's going to come check it, but they cannot be working for these companies, because if you're working for these companies, because companies separate from themselves, right? So you're working for a different entity, and if you work for those entities without having proper work authorization, then that's illegal.
Understood. Because even that is actually common, because I did see, and a lot of lawyers and attorneys have also discussed that they come on a specific visa, and on a freelancing basis, they start their own company. So right now, they're just illegally starting the company. I don't understand.
Yes.
A lot of people basically don't understand this. They're like, no, okay, I'm just going there to give business, or, I have my own rights. So can you in detail explain what are the cons that these people can go through? What illegal, cons that they can face? I hope the viewers are listening to this again and again, because it's a very common question that we get.
Yeah. A lot of people are under the assumption that if they do a corporation, okay, then nobody's going to come check it. Okay, because for a corporation, when you have a corporation, right, unlike a corp, you would not be like, for example, if whatever the income that the company is making, you will not be receiving it on your tax returns until you take dividends. So people think that just because it's not showing up on my tax returns, I don't have to worry about disclosing it, right? The fact that you are actually running a company itself is illegal. Okay, but you could be a passive investor. So while on H1B, right, you could be a passive investor into another company. For example, buying a stock on the stock market, right? So you're buying the stock, but you're not actually working for the company, right? Or maybe I'm investing into some real estate, right? I'm investing money into real estate, but I'm actually not working for the real estate company. Maybe I'm investing into a restaurant, right? If you're doing that one, then you have to be very careful that there is a proper operating agreement that clearly states that you're only a passive investor and that there is someone else who's actively managing the company or the restaurant or any other business. A lot of people ask me, hey, why can't we do the same thing for an IT consulting? Okay, here what we need to notice that IT consulting firm, it's your sweat, that is the investment, not the money, right? Because you cannot show that, hey, I'm a massive investor, I invested $10,000 and this company is making $1 million. No, that doesn't work, right? Because it's a professional company. IT consulting firm is a professional firm, and unless you are investing in a big company and then you're investing huge amount of money for a very little share, it will be clearly evident that you're the one who's actually running the business. You cannot run the business or you cannot be involved in the day-to-day operations of the company unless you hold a work authorization to work for the company. Whenever you have such situation, we recommend applying for a concurrent H1B. So for example, if you're working full-time for a company and you want to run an IT consulting firm on the side, right? So maybe somebody else started the company and then you could be a minority shareholder in the company or less than 50% shareholder in the company. Do your H1B, concurrent H1B through that company. Maybe when it could be even part-time, right? If you do that one, then it's perfectly legal for you to have that.
Understood. So, Somireddy garu, let's get back a little. Now, let's again get back to the fact that I lost my job. So, I lost my job. I am on a H1B, but my husband, he is my dependent visa, and let's assume I even have 2 kids who are rightfully the citizens of USA because they were born here. What is their situation? What will my dependents go through?
Good. So, in this situation, right? So when we apply for a change of status, your change of status to B2, we will apply for change of status for the dependents also. Okay, but that's only a temporary relief, right? For 6 months or whatever, right? If you want to stay here for a longer time, then what you could do is you can apply for EAD based on if you have an approved I-140, right? Then you would be eligible to apply for an EAD. Similarly, if you're applying for a change of status to F1, then your dependents could get F2 visa.
Yes.
Yeah. But other than that, there are not too many. Just because your kids are US citizens, unless you have an approved I-140, it will not help you in any way.
Understood. Because a lot of people even say that, but my children are the legal citizens of USA.
No. Until they reach 21, they cannot help you in any way.
Yeah, I think, can you explain that in detail actually, because a lot of people really don't understand. They say, no, my child, so he is completely my, US citizen and I have to be there to take care of him or her.
No.
So till what age can you just briefly explain that too?
Okay, so even if the child is a US citizen, you're not so basically what happens, there is only one way to stay in the country by using your children's citizenship, which is by proving that there will be if USCIS removes you from the US, then it will cost an extreme hardship to a US citizen child or spouse. Okay, not regular hardship. It should be extreme hardship. So if you have US citizen kids, then they will say, hey, take the kids, go to your home country, stay there until you're able to get proper work authorization and come back here. The children, once they reach 21, they can the children can always come here. And Also, once they reach the age of 21, even if they're in school, they should be able to sponsor their parents. So if the children are, if not in school and not able to make enough money, then they can have a joint sponsor.
Understood. So, Somireddy Garu, of course, a lot of H1Bs who are already there in USA, they generally start their green card processing, or they're on the verge of getting their green card or a citizenship completely. So, what will happen to that process in the midst if they lost their job in a layoff?
Good. So usually what happens is, if a person's I-140 is approved, then their prior date is set. Okay, unless USCIS revokes the I-140 for fraud and misrepresentation, or USCIS revokes the I-140 within 180 days of its approval, the employee will still be able to use the I-140 for getting the priority, quoting the priority date, and also to extend his H1B past 6 years and apply for his spouse's H4EA. Right? So if you have a situation where a person was here, he had an approved I-140, and then they could not procure a job and they had to go back to India, the other option that they have is to file a form I-824 requesting consular notification of the I-140 approval. Right. So what happens is, if we request for consular notification of the I-140 approval, right, when a person's final action date becomes current, then the I-140 will be sent to the National Visa Center so that the person can attend GC visa stamping in India or wherever they are from.
Understood. So, Somireddy Garu, do you want to get into a little bit of tax questions that we get, or do you want to get into another topic?
Good.
Can we do? Okay.
Yeah.
So the another question that we had was, how will their tax status and how will that get affected if they had a job layoff?
Yeah. So, number one, first thing, if a person is in F1 status, right, then they don't have to pay Social Security and federal Medicare taxes. That is the biggest advantage that people who work on OPT or CPT would have. Okay, unlike H1Bs and L1s or any green card holders or citizens, right? These guys do not have to pay Social Security and federal Medicare taxes. Also, that when it comes to the tax thing, right? So the taxes, based on the number of days the person is present in the US, they are taxed accordingly. Okay, so if they stay in the country for more than 180 days, then they are tax resident. They have to pay the taxes. Okay, so even if they move, they change their status to whatever B1, B2, or not, right? So for any income that they have received while they are on H1B, they have to pay taxes on that one. So they'll have to file the taxes at the end of the year.
Yes. And also, are there any tax benefits or credits that people must be, aware of if their job got laid off?
No, actually, they are not eligible for any tax, like any of those benefits, unlike US citizens or green card holders.
Understood. Okay. So, Somireddy Garu, my next question to you is, when the H1Bs are laid off, so a lot of people who have just started their business and who are not legally, termed, not legally, signed or whatever that is with the government, and if they just started their business or whatever, so are there any specific another rules for business, or do they have to just follow with the H1Bs only?
So there are certain options available for entrepreneurs, but that is completely different, right? So in certain situations, like for example, if a person had a company back in India, right, then maybe they are trying to expand their business to the US. Right? So then what they can do is they can apply for L1A new office, right? To start a business in the US. And once that, typically L1A new office is granted for 1 year period, and after the 1 year period, they can always get L1A extensions. And using that one, they can also apply for a green card under EB1C category. Okay, but if a person is in H1B and then opened like if you have opened a company here, that is illegal, right? Unless they are a passive investor or they hold H1B through that company.
Yes. Yes. Somireddy Garu, this is another question that I wrote down. It says, are there any expedited processing options available for changing or extending any of the visa that have come into layoffs?
So, you have premium processing is available for changing your person's status from H1B or any other status to F1. So premium processing is available for F1. It's not available for B2. It's not available for H4 also, unless the person is applying for H4 along with their spouse's H1B under premium processing.
Understood. And now let's get into the consequences. This is when it gets interesting. So I want to know, let's say I did not get a job. Again, let's get back to me losing my job, unfortunately. So what is going to happen if I don't find a job in that 60 days grace period? So what are some consequences that I can be bearing if I overstay in the USA?
Well, if a person overstays here after 60-day period after losing job, right? Then they're considered to be violating their status, right? If a person violates their status, they can be deported, they can be stopped from entering into the country next time they go out of the country, and they can also they may be barred from applying for adjustment of status. But if a person's I-94 actually expires and if the H1B is withdrawn, right? And then they'll start accruing unlawful presence. If a person has accrued more than 6 months of unlawful presence, then they are barred for 3 years. So barred from entering into the US. Similarly, if a person accrues more than 365 days of unlawful presence, then they are barred for 10 years. So I highly recommend that if a person loses job, if they're not able to find a new job within 50-day period, not in 60 days, 50 days, then I recommend applying for a change of status to either B2 or H4, or in some circumstances, it can be F1 also.
Yes. Somireddy Garu, we have last 2 minutes, but I wanted to cover just one simple question. I'm sure it's a very stupid question, but I still want to ask. So let's say I got my, they told me that, listen, Shivani, from tomorrow, or let's say you have 15 or 20 days of notice period, and from then you won't be getting paid. So is my, job gone from 15th or from 17th today? Or do I have 60 days more plus the 15 days?
Good. The 60-day period starts from the last date you actually work.
Okay, got it.
Okay, so if they say that you're terminated today, but you're getting severance for 2 weeks or 3 weeks, right? So the 60-day period doesn't start from 3 weeks. It starts from today on.
Okay. Understood.
Okay? Yeah.
So even though you're serving or not serving the notice period, you still have only 50 or 60 days.
Yeah.
Okay. I think Somireddy Garu.
So usually, if a company says that, hey, you have to continue, we are issuing the termination notice, but the termination will go into effect 2 weeks from today, right? So if that happens, then the person may be required to work until the 2-week period. If they so basically, I recommend that you count the 60-day period from the last date that you are employed with the company. When I say employed, actually working.
Understood. Yeah. Understood. And I think with that, Somireddy Garu, we had such an informational episode today. Thank you so much, Andy, for tuning in.
Thank you, Andy.
Yeah, thank you again for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.